Thanks again for joining us today. Obviously, you're fairly renowned for the area of the industry that you're working in, numerous cases. I think what would be great for our attendees is if we kind of start back with the history a little bit. So, correct me if I'm wrong, I believe this all kind of started when you submitted your own access request to Facebook as a student. So can you kind of talk to us a bit, what made you do that? What was the kind of output of that, and why that kind of led this journey that you've gone on?
So first of all, really sorry for not to be there. I don't know if it was explained, but my passport was gone, so I should have been on the Eurostar yesterday and with you all, but now I'm stuck. Where all of this came from, I think, first of all, I was already starting to kind of program in school, have a bit of an idea of what computers do, which for lawyers is a bit exceptional sometimes because they talk about this thing without really necessarily knowing what goes on. And then there was a lot of the parts were exchange in the US. I was a high school student, and suddenly you were at a high school in the middle of nowhere with all cameras and surveillance, and everything was put in numbers and you were a number, you got a number as a grade. It kind of felt, these things that are oftentimes said that way actually then felt a bit real, and you started to think about it. I think that was one part. Then obviously that was still the decade after 9/11, where we had all these new surveillance ideas that were floating around. And then I was actually studying in the Silicon Valley for half a year, and that was kind of probably one of the triggers. I already did privacy before, but what was interesting is that a lot of the speakers there, in simple terms, and I'm simplifying that a lot, said, all of that is kind of cute what the Europeans are doing, but if you actually just violate the law, nothing happens anyways. So we, just going to continue to make a load of money without really caring about any of that. Obviously, that was pre-GDPR, but that is still a bit of a notion that I think designed a lot of the early internet, or a lot of the systems that we're still using today to a large extent are just inspired by this not being really relevant to our problem. And I think as a lawyer, then, to get back to that, makes it a very, very interesting topic, because it's really something compared to other areas where you don't have 100 cases from the last 100 years that define things in detail. A lot of the questions are really new, and I think then also need kind of a very good legal thinking and good analysis and good, capacities to kind of work with that, which are really kind of challenging, but also really interesting to do. And that, I guess, captured myself. I thought I'm going to file a couple of complaints with the Irish DPC, and that's all going to be fine, and I move on to something else. And then 10 years later, it's actually more than 10th year anniversary. My, for example, data transfer complaint is still not decided. Technically, today it went to all the courts a couple of times, but it's still not decided. And then you're kind of stuck in these topics in a way.
Yeah. I think the fact that it's 10 years since the first complaint went in, and we're still here and still having these discussions, probably indicates how complex the issues are and everything. So you mentioned there you filed your first complaint in 2013, and this obviously largely came off the back of the Snowden revelations. So I think it would be really great is if we can go through what did Snowden reveal to everyone, because obviously it had such a big impact on everything, and why and how it became so important, not just in your career, but to all of us here today.
I usually call Snowden a bit like the Chernobyl of privacy. Like the first time it was a bit undeniable that there is a problem, maybe. I think that is to a large extent what happened there. What's interesting is, the law existed before. They did a lot of the surveillance after 9/11 without a legal basis. Then it was later legalized in 2007 with FISA. But the law is oftentimes so cloudy, and especially in that area, that it's really hard to really get an idea of what's going on. And that was interesting to just have slides to say, okay, at this date, that specific company was hooked up to the system. And that then allows you to litigate. We could have theoretically, from a legal perspective, litigated that ever since. But it's going to be really hard to be in front of the Court of Justice and say, from that law, they could have theoretically done this and that. No one is going to take that seriously. So I think in that area, it was kind of like really also for the general public to raise that awareness. Judges read the newspapers too. I think that was really interesting. And to be honest, even today, it would probably be harder to bring this case anymore, because some of that wore off and some of that is just last decade's stories even. And that's also interesting. There is actually this new P-Club report that came out where they even said that there is new techniques that the US is using since then under the same authority. We're still discussing largely the old 10, 15 years ago way of doing this. And there may be a lot of new technology as anywhere and a lot more happening. So we're still have a huge delta of knowledge ever since then on what's really going on. We do know that what they did ever since then is still existent because that's continuously in the reports. But the details are actually then something that will probably need another, I don't know, 50 years to get a similar idea of what's going on.
Yeah, we almost need a Snowden's younger sibling or something to get involved and release some of that. So I suppose in terms of what Snowden revealed about the surveillance around Pfizer and what was going on, that we know was going on, could you give us a little bit about detail about the different ways that the US were using these surveillance tools to kind of target people and why that was such a big deal?
Yeah, so basically Pfizer is an interesting law because what it does, it only says you need an electronic communication service provider, and that electronic communication service provider. So that's important because it's not every US company. It's basically the big cloud providers, telco providers, and so on, but not every recipient in the US because largely it said everything in the US is terrible. This law actually only applies to certain companies, but it's the companies we all use. Secondly, what you need is foreign intelligence information, as it's described, and that is an extremely broad definition. That's basically anything that's of interest for the United States. So it's largely an espionage law, and it's oftentimes painted as a, oh, we're all in the same boat against terrorism and blah, blah, blah. But actually, the law allows to do terrorism as well, no doubt, but it goes far beyond that. In the latest iteration of the executive order, for example, there is, it used to be 6 reasons for bulk surveillance under the old system, the Privacy Shield system. Under the new one, the transatlantic data privacy framework, if I'm correct, you even have 8 legal bases for bulk surveillance, as they call it. And bulk surveillance is also defined actually in very narrowly, but like very broadly, so that a lot of it doesn't really fall underneath these under these limitations. But for example, what's included is climate change or international health crisis. And I don't know what the NSA is going to do to, overcome climate change. That will probably be one of the most important things to do for them if you compare it. But you see how broad surveillance can go if that's the purposes. So Pfizer is the main one we look at. Pfizer is interesting because it allows to require a US company to provide basically instant access to the data. There is a big discussion of, is that mass surveillance, bulk surveillance, imminent or whatever, but the reality is they have to open up an API that allows capturing the data based on what they call identifiers. An identifier can be an email address, an IP address, some other identifier that you have in a social network, like account number, something like that. And basically, there has to be a system where you send the identifier and you get the data back without anybody at the company materially reviewing that or actually physically putting it together. And we know from the slides that from Snowden disclosures that, for example, the capturing of voice over IP is part of that. So it has to be an instant access. That is not defined in law. So even in our litigation, they were like, by the law, it could be paper that's sent back and forth. And I was like, good luck with voice over IP, printing that out on paper. But, so they are sometimes a bit like discussing what that really means. But in reality, we know that's the at least our working hypothesis on how it works. What's then the other legal basis that's really interesting is Executive Order 12333. That allows to go much further than Pfizer, but with the difference that there is no obligation of a service provider to comply with it. So if a service provider, which we largely assume the service provider do, for the benefit of their doubt, so to say, they're not interested in doing that and say, no, we're not doing a voluntary disclosure of stuff, which we know AT&T, for example, did. They did a voluntary one. But let's assume after all the discussion, the appetite for voluntary data sharing is a bit more limited. That could still allow, for example, the NSA directly to capture data somewhere. That's extremely broad, and it basically says you can get any information that's relevant there and that you want to have. Without even going through the hoops of Pfizer. The last thing I wanted to say about Pfizer, because I think it's really important if we look at solutions as well, because the problem here is usually as Noib would bring a case and, say, change the cookie banner, make that nicer, case done, and we're in compliance. Here we have a political dispute. So we basically have a American law that requires surveillance and a European law that requires privacy, and as a company you're squeezed between them. There's not much you can do. And I think what's interesting, however, is that we actually agree largely on the level of how far government surveillance can go. We oftentimes do not agree in commercial space, but in the government surveillance space, in the American tradition to be like anti-government, limited government, and so on, we're actually very close. And it's interesting that under the Fourth Amendment, most of the surveillance would actually be illegal if it's done on American citizens or US persons, as it's called. So the only thing that the law really does well is that it separates the data stream into like a European or like a non-American and an American data stream. For the American data stream, you're not allowed to do anything. And for the international one, it's fair game and you can pretty much do whatever you want. That is also the minimization and targeting procedures. That's basically the procedures to filter that out. And these procedures have to be approved once a year by the courts. So the courts are mainly concerned in is the filtering of non-Americans and Americans working well. They're not concerned with the individual tasking of an individual person. And that is where the same rules would apply to everybody. And I think that's in the long run going to be interesting to say, can we have among democratic countries in the world a joint set of, how far can governments go on government surveillance? And typically we do have, there has to be probable cause. There has to be a judge approving it or some independent tribunal. There's different versions. That would be interesting in the long run to get to be able to have free flow of data. Like we also in the litigation, the Schrems II litigation, really tried at the Court of Justice to explain to them, this is doable with encryption, this may be doable, blah, 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 blah. So we try to keep the door open as far as possible, even though my name is usually then attached to the opposite. But there is a certain limit on what's doable, and I think in the long run we're not going to get, I usually say, China or Russia into the boat, but we could probably get the Western democratic, whatever you want to call it, countries to agree to some baseline, which we'll need unless we get the splinternet or the balkanization, as they say, of the internet, because I'm giving a very long answer, sorry for that. Because I think fundamentally the underlying issue is the member states or also the different countries in the world are regulating the internet more and more. And because we have different cultures and different democracies, we come to different rules. And then the big question is, where do your rules start and end in a cyberspace or in a very interconnected bubble? And we don't have any agreements. We don't have international agreements on that. And that, I think the privacy sphere is the first one where we have that, but we'll have a lot of other topics where it's going to be similar. In Europe, we can build a bubble and make that somewhat consistent so that at least there's a European consistent system. But then when it becomes international, we really need to go into national agreements. And they exist. I mean, there is Convention 108 ever since the 80s, but they weren't really used. There was no pressure to go into it. And I think that's where a lot of the solutions lie in this discussion.
Yeah, that culture aspect, I think, is really important because I think, like you said, the US position is, we protect our citizens, and it's very much, and even the state laws are very much around, residents or consumers within those states, whereas the European approach is kind of like an all-encompassing. I was having a discussion just yesterday about what actually constitutes a comprehensive privacy law, and one of the factors is that it should apply to all, and I think that's what's kind of missing in the US. In terms of that split, and that split between, well, what are you doing with US citizens, what are you doing with everyone else? Obviously, that played a massive part in what you were doing with the cases and bringing the case to the DPC. Obviously, the issues with the first case for under Safe Harbor and then the challenge to Privacy Shield were largely the same from what I can tell. What were the biggest kind of challenges you faced in bringing those? What were the large outcomes and the findings that really came from those decisions? And did you go in expecting to get these decisions, or was there an expectation, let's ask for the moon and maybe we'll get the stars kind of thing?
A mix of everything, I guess. So I think the first case was we actually in all the cases always said the DPC could decide alone. We don't need to go to the Court of Justice. It's a rather simple situation. In the first case, the question was that the DPC said that it would be frivolous and vexatious, my claim, so absurd that it doesn't need to be even observed. And that was, after all, actually the issue that went in front of the Irish High Court. And we said, okay, there is actually an option under the safe harbor framework. You can stop the data processing despite the adequacy decision in individual cases. And we're like, if all your data goes to the NSA and they're on the list of the NSA, that may be one of these individual cases where we want to consider that. That was actually our argument, to say the High Court shouldn't even send it off. Let's keep it with the DPC and so on. But the DPC really, I mean, at every corner really tried to sabotage these procedures in very vicious ways. I have to say that in Austria, some of the things that the DPC did would really be abuse of office and a criminal offense for a public employee to do that even. To give you an example, in the first litigation, they had us go all the way to the Court of Justice on safe harbor. Once we won it, they then actually took out an email that they got 2 or 3 years earlier saying that Facebook actually uses the standard contractual clauses. So they had us go all the way to the Court of Justice on the wrong legal basis in reality. I mean, politically it was interesting because politically the bigger issue is US data transfers in general and not really Facebook's SEC. So politically, what actually quite good for us. But from a litigation perspective, there is usually a duty of candor of the public authorities in Ireland to actually provide that. They then gave an undertaking to the High Court that they will swiftly decide. That was in 2015. That's 8 years ago. You then ask, what happens if you break an undertaking to the court in the common law system? And the answer is you go to jail, but just not if you're the DPC, because that's only for normal people, not for the regulator. And you go, I mean, we can go on for 100 of these things that they withhold documents strategically, also from the European decision bodies, that they delay cases really strategically and really just move it out and out and out. We saw that now to move it so far that the new framework is coming into place. And it's a strongly, I mean, there's a strong indication that's a protectionist approach for, shielding the good place for not paying taxes and not being really subject to the laws. That's a bigger topic, I think, to have. That goes far beyond my expertise, but that is what we saw. So going back to like your question, I was very confident that we'll win both cases because the case law is actually quite clear. If you already look at the existing Court of Justice case law on data retention on similar situations, where, I mean, if you throw out data retention, which is only the metadata, you kind of have to throw out this because it's definitely more than that. We were, for example, surprised. This is a bit like asking for the moon or asking for the stars and getting the moon. We did say, for example, that this would be a violation of the essence of your fundamental right, just because the case law said if it's actually mass surveillance of content data, it's a violation of the essence. We argued it. We didn't think that the Court of Justice would go that far. So actually my Irish colleague, our Irish solicitor, read that part of the judgment because, when you get the judgment, you have to react really quickly. So we divided up and literally everybody's just reading some chaotic scenes. And he was like screaming over, like, we got the essence. And I was like, that's weird. But that was probably the only thing that was a bit going further than we expected. Same thing for the second litigation. For us, it was really important to be truthful to the Court of Justice, really explain the things to them well. One thing that came out of it were sometimes as a political actor, and to a certain extent in these litigations as well, you wonder if you should do it. What we saw here is we, for example, argued for the supplementary measures because we did say, okay, there is, and it only came from our submission. So the whole idea of supplementary measures that a lot of law firms now made millions on to kind of advice on literally came from our submissions only. To say there are situations if you have end-to-end encryption and it just travels through the country and is not going to be looked at there. There are these technical solutions. We wanted to recognize them and have them in a judgment. What you see is that instantly, if you just have 1 or 2 of these words in a judgment, the whole industry tries to kind of fly jumbo jets through these little exemption thingies. So strategically, you oftentimes wonder if it's not better for you to just shut up and just not address the issue. We have at NOIB a very academic approach usually to these things and try to really, do that, and that works very well for us. I mean, the judges also recognize that you're not asking for crazy, you're really kind of trying to be useful in your submissions. But that then backfires oftentimes if the big law firms have to give some answer to their client and then come up with crazy.
Yeah. I suppose when you're looking at the case and you're looking at all the issues around the surveillance and stuff, what is the biggest issue with the approach to surveillance? Is it the split between US and EU, or is it more focused on the fact that okay, yeah, they are targeting EU citizens, and is it more around the lack of redress and the lack of fact that they don't have rights around what's going on?
I think it's both. Like usually, so I think the U.S. and non-U.S. thing. What I didn't add before, we have similar laws in Europe. We do have similar situations. For example, in Germany, there is no place I can go to. There is no redress. The problem is that the national security of a member state is exempt from EU law. Now, there is a discussion of how far that goes, if that also includes the companies aiding that, or if the companies are within EU law and only like the Secret Service is not. That is a different discussion to have, but that's going back to this international agreement discussion. We also need to really think about what happens there. And the Americans do have a fair point where they say, oh, it's hypocrisy because you do the same. I don't think it's exactly the same, because we do still have the charter that applies here. We do still have the convention that apply. The convention applies here, the charter does not. And we still have basically 2 to 3 member states currently that really do that. The UK was typically the argument that they brought before. They basically said, let's look at the shittiest country in the EU, that was typically the UK, and then say, oh, we're essentially equivalent with that. That was like in simple terms, the narrative. Now they have to go into France and Spain and Germany to argue that, and that's not that easy to argue, and Sweden does stuff like that as well. But the majority of the member states does not go that far. And so it's a bit more nuanced. There are member states that do that, not everybody does it, and so on. And so that is the citizenship debate, but that's a broader issue that we have to address broadly and not just say the Americans do that. There are member states that do the same thing. First point. The second one on what's the issues, I think there is an element of the, can you just spy on someone without any probable cause or any reason? I think that is the material law protection that we need, that we typically have for wiretapping in most democracies, and to my understanding, with different nuances, but the general thing is probable cause. There has to be some reason. There has to be a crime, for example, and that is not even existent in US law. And then the redress factor comes in. It's like you can have the best law, but if you don't have any, either there's 2 options, either pre ante decision process, so that you really have to call the judge before you wiretap, or ex post have some way of going someplace, which then usually requires information of the individual that they can even bring a thing, where there is discussions of how the information should be, how limited it is, and there's a lot of room for limitations here. But there has to be something in that direction. And that is going to be very hard, again, with the New Deal, because both of it does not exist. And even the kind of thereafter process is so limited in information, and so like de facto impossible to ever even get to this court that they installed, which is actually not a court. That it's going to be very hard to see that as a reasonable and proportionate limitation of your rights. And because, for example, information duties, they may really be 20 years later because it's a really ongoing big thing. But at some point, there's an hard argument that you can never inform anybody 50 years later that there was any surveillance. And that's going to be really hard for the Court of Justice in an assessment to say, yeah, that just never happens, and that's always proportionate to never happen.
Yeah, it's really. I think we've obviously touched on the New Deal. Privacy Shield is putting lipstick on a pig. What's happened to the pig now, Max? You know, has it had Botox? Has it had a makeover? What's the difference between Privacy Shield and TDAP?
The pig retired because a PR person that at least once worked for Meta put the pig next to a Nazi pig and said that we're using Nazi rhetoric because we're also extreme, which in the German-speaking area is basically accusing someone of murder. So we had to retire the pig because they put it next to something out of the Stürme and said that would be where we'd take it from, which was amazing on how, you know, let's say, interesting conversations can end up. So I'm not going to use that anymore because just to not have any attack surface. The reality of what we have is we have the same deal with the third headline. If you look at the commercial side of it, it's still the old safe harbor principles. They're basically the same. They come from the 90s. They're fundamentally different than the GDPR. To give you an example, you do not need a legal basis. You do not need consent or any of the other 5 legal bases. You just need opt-out in very specific situations. So the general rule is you can do whatever you want to do with the data. Which is extremely different than I guess, as most of the room knows, the GDPR is. And on the commercial side, on the government surveillance side, It's largely now there is a new executive order that they put out and say is all that wonderful. The reality is that is largely a restatement of the PPD 28, which was the Obama executive order that was in front of the Court of Justice in the Schrems II litigation. So I think we need to put them side by side and see what is the difference. If you do that, you see that certain elements are clarified further, or there's a bit more, like, the text is generally a bit better, let's put it that way. It doesn't necessarily say something different. So there are elements that are, to give you an example, we always knew that the president can secretly change that at any time, and we would not be informed about an amendment to this. And now they state that at the end, which is from a litigation perspective useful, because you can, now we all agree that that's true. That's good for clarity purpose or for transparency purposes, but it doesn't really change the problem. and it's usually, I'm generally a bit like, also in privacy generally, we try to oftentimes say, oh, let's have more transparency, but just, you scream louder that you killed someone else still makes you a murderer. So transparency doesn't really solve the problem in these situations. And that is a bit what we see with this executive order, that some of it was a bit like further clarified, but not really materially changed. It's not that easy to do a side-by-side because the text just got redrafted and they kind of took all the things apart and reassembled it. But fundamentally, it's the same substance that's in it. There are elements, as I mentioned before, where it even goes further. There is more basis for bulk surveillance, for example, than before, which is also going to be hard for the Court of Justice to accept. There is one big element that they put out for the material law, which is that the US now agreed to proportionality test. And that is the big headline that they had in the PR. And that would be really, really interesting and would really make a huge difference if we would introduce the European concept of proportionality for mass surveillance into the American world. That would be, there's no Nobel Peace Prize or whatever for law, but that would be one way you could probably think about it. The reality is that's not done. So they will have an American interpretation of proportionality, and already said that what the Court of Justice found not to be proportionate, they will continue and still stay proportionate in the American interpretation of it. And that shows to you how that is mainly a political deal. It's not done by lawyers that really said, okay, we changed the law, we had the relevant changes. It's a political deal, and they wanted to have the word proportionate from the European side. They got the word proportionate, but got it hollowed out with a different American meaning. So that is, to be honest, if you're the judge at the Supreme Court of the European Union and you get that presented, it will be a matter of authority to just tell them, fuck off. That's going to be very hard for judges to told the commission twice, you have to come up with a materially better deal, because we tell you it's not just disproportionate, it's a violation of the essence of a fundamental right, so we're at the very end of the scale. And now you come up with, oh, we agreed on the word, but not on the meaning. I feel really bad for the colleague that has to defend the commission in this, because that person is going to get toasted like crazy. And the second thing is for redress. They do a kind of a similar approach. They used to be the ombudsperson, and they upgraded that position in certain elements that are actually interesting and actually would even allow theoretically that something happens. But all the problems that we had before exist still. It's almost impossible to get to the ombudsperson. So in the old system, no one has ever managed to actually go to the ombudsperson with a complaint. Zero. So that tells you a lot about the requirements that you need to fulfill to even get there. I would have to go into the detail, but there is basically you have to show that you had an issue with the US government that is based on data that was transferred under one of these instruments after a certain date. Now, give you an example, I was on a security list of a flight to the US and was like, okay, I'm put on a security list, so maybe that's a good case. Now the Austrian DPA, rightfully under the rules, rejected the case, saying I could not prove that that's based on my Facebook data that was transferred to the US after a certain date, because it could be on any grounds that I was put on that list. And that already makes it impossible to even reach that system. Now, there was criticism that that is an executive body and not independent and all that kind of stuff. So they wanted to have a court. But installing a court in the US requires an action of parliament. And we all know that right now they don't even have a speaker. So generally any of this is impossible in the US, because there's simply, that's an additional factor that just the democratic process in the US is so broken by now, unfortunately, for many reasons, very unfortunate, because if the beacon of democratic societies globally is giving this picture. It's very easy to convince someone in Russia and China that democracy doesn't work, just with a little asterisk. But that's the reality we're also operating under here, and then all the people involved operate under. So they couldn't get a court. What they did is that they had a second level of an ombudsperson, where it's not one person but multiple people deciding, but otherwise it's exactly the same text, it's exactly the same mechanism. And because the European Commission insisted that it has to be a court, they called this a court. So it got a name tag court, but it is not a court. And that is the things where, I mean, every judge, even if they're not interested in these topics, will see that and say, we're just litigating about Hungary or Poland having a proper court system about some appointment issues that I don't want to belittle, but like if you compare it to, oh, we don't even have a court, but we have a sign that says court, it's like, what are the judges going to say? Are they, and so I think it really shows also that we have a huge problem from a constitutional perspective, that if the Supreme Court of the European Union tells the Commission you can't do it, and they just issue it over and over and over again, this will become, I think, in reality, largely a constitutional debate at the Court of Justice of how far can the Commission just ignore them. And maybe even if the deal would be better, it may still be questioned even more, let's say, than the first deal, because of the history and the baggage that it has with it. So I think that will be another factor why we are in reality very confident. Obviously, you never know. It's a close thing, but there is reporting that the Schrems I case was actually a 15-0 decision by the Court of Justice. That's usually undisclosed. There was a leak, apparently. It was in a German newspaper. So that may tell us a bit of how likely it is that, we just flipped with a little change, one or two judges, and now everything is wonderful.
Yeah.
Like winning the lottery has better chances, probably.
Yeah, I can say I like those odds for your next challenge. I suppose before I ask you when and if there's going to be a challenge, you touched on potential solutions earlier.
Spoiler alert, yes.
Yeah. Spoiler. Thanks, Max. In terms of solutions, you mentioned a few things like, we need something global, really, but there's still this talk of a federal privacy law in the US. In reality, would that really make any difference because of how the Constitution is set up around US citizens? Is it just kind of a moot point? It wouldn't make any difference?
I think it's more of a political point. So in the commercial sphere, let's zoom out. Generally, for a third country, we can have a situation where there's simply vacuum of law. There's just no legislation whatsoever. In that situation, you can contract in. That is absolutely making sense. That's the reason we also said the SEC should stay. Actually, there was a challenge to the SECs mainly in Schrems II, and we said, no, the SEC should really stay, because if there's a third country, to basically contractually follow European law is a system that has arguments why it's not perfect, but generally, I think, acceptable. The problem is if we have a conflict of law situation, so we don't have a vacuum, but we have a different law that interacts. So I think the federal privacy law would usually be on the commercial side of all of this. That is something that would be nice. We would not have to have like the privacy shield principles. We could accept something that would make a lot of the business transactions much easier and all of that. So I think there is a good argument to be had. But we can fill that contractually. We can fill that with principles that are proper principles, probably not the one we have right now, but they're easy to change. That is like not technically overly complicated. The real challenge is on the government surveillance part, where there's simply this conflict situation. And I'm not an expert in any of that, and I'm not an expert on what goes on in Washington, but the people I talk to usually dare say it's just politically almost impossible for a member of parliament in the US to say, I'm running on the we give more rights to foreigners ticket. So that is just not, that's basically getting people voted out of office, not into office. So our theory of change there was that potentially, if there would have been proper enforcement in the European Union, if the customers in Europe would have said, I can't use that product anymore because I have to follow the law, there would have been enough pressure that the US companies have two options, either to really segregate, which partly they did by just saying, we host in Europe, but still having the access, so it doesn't really help you, to be honest, because what I forgot to say, FISA has global reach, so unless you are not able to access it from the US, you're under FISA. So a lot of that is to be honest, a bit of a false sales practice as well, where to not say more. But if I'm told by a company that this is fully legal and blah, 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 and it's not, then I know the claims I can make in court to actually get my money back. But that being said, I think that is where the problem lies. Our theory of change was then that the Silicon Valley will simply have a problem to sell their products globally anymore with these laws as a baggage in the long run. Probably not right now, but let's talk about the next 20 years. We will have a situation, as the US is now unhappy about TikTok and Huawei, where they say, oh, now it comes in the baggage with any of these products comes Chinese surveillance. We'll have the same situation the other way around. Maybe, not an authoritarian state and so on, but who knows what happens after the next election and how happy people are going to be about the government that comes up there. But we will have that situation, and it's I think for the U.S. industry a major factor if they want to be the global provider of all of that, and they are under these legal obligations. They will have in the long run a hard time to sell their products, and I think that is where there could be a theory of change, that basically the Silicon Valley at some point, where there's a good point in time, where there's enough pressure, where the right people are there, walks up to Capitol Hill and says, guys, all we need in reality is 20 additional judges that just sit here and say yes and no on individual selectors on somewhat of an objective basis. Absolutely doable. I can tell you in Austria for wiretapping, we have a cell phone journal judge that in the middle of the night wakes up and says yes or no and shit like that. That would be the cheapest solution for everybody as well. I think also economically thinking, we kind of have the problem that the issue is pushed down to the smallest or the weakest player in all of that, and that's usually the SME or the last user of some software, and that is just not overly efficient. Like the most efficient one would have been the solution on the U.S. government. Second most efficient is probably if the big U.S. tech provider solved the problem really, and not just in paper fights. Yeah. And now we have it at the very end.
Yeah, I suppose there's this. If it's not going to happen in government, then if industry pushes it and kind of has an acceptance, because there's a small degree of sympathy for some American companies, I suppose, because they can't do anything about the government law unless they really push it. It's kind of enforced on them. So yeah, that's a really interesting perspective. I'd like to move onto the UK, or the shitty UK, as you called it earlier. Thank you very much.
I didn't say the shitty.
Yeah, don't quote on
Europe, as far as I remember. I hope that's what I said. Otherwise, I hereby correct the record.
Yeah. So only a couple of weeks ago, the UK kind of announced its own adequacy decision with the US under the UK extension to the EU US DPF. It's due to come into force next week, today. What are kind of your thoughts on that? What would be the impact of a successful Schrems III on that decision? Mm-hmm. And where do you see that in terms of the UK's own adequacy with the EU?
Yeah, I mean, you have this kind of connected, these three connected bottles then in a way, where if you chop off one connection because you say that's a violation of fundamental rights, and then the data flow through the UK to the US, you obviously have an issue. And then you would basically have to ask these questions there as well, which politically are going to be really interesting, because, I mean, quite honestly, we were asked a lot if we want to challenge the UK adequacy after Brexit because of UK surveillance laws that would then, because it's not the surveillance laws of a member state anymore, you would suddenly have jurisdiction of the Court of Justice in that moment. At the time, we said we're not going to do it because, quite honestly, it's a fucking bonfire and of craziness where I don't want to put additional oil onto it, because I literally never understood any of this. But that being set aside, I think at some point these issues will come up as well, and it's going to be hard because especially, and everybody in the room probably knows that better or has a better view on that. From a UK perspective, you would then have to say, do we cut it as well to the US? Or are we going to get challenged from the European side? Where is the bigger alliance? What's the one that we want to stick with most? And at least if I look at the ideas of adapting the GDPR to a UK version, I could see that politically the alliance may be more in Washington than in Brussels on all of that. But economically, it's probably the opposite. And then, you will see these tensions at some point. So I think that's to be honest, an additional element. We had a similar situation with Switzerland to a certain extent because Privacy Shield already had the Swiss extension. And the Swiss first said, okay, that was technically not challenged. It's technically still there. But then they rather soon actually gave it up as well because of exactly that problem. Obviously, Switzerland, different situation, smaller country, more, part of the European continental system than the UK now is. That's going to be really interesting. But to be honest, I think most people in the room probably have a better idea of what's going to go down if that happens than I do. So I'm probably going to stop there.
Yeah, thanks for that, Max. I think one of the most interesting things around the proposed changes are, in terms of adequacy decisions, one of the criteria is now to consider the economic value of that, and can kind of see adequacy decisions being bundled into trade deals as the UK's economy is booming at the moment, as we all know. Max, that was absolutely fantastic.